Hello, are you there?
Good morning, ma. We are here.
Good morning. Good morning.
Good morning, ma.
Yeah, so I think we can start the class. I think we can start the class. Good morning again.
Good morning, ma.
Okay.
Good
All right.
afternoon,
Good afternoon. Okay, so we can start the class. Yeah, so today I'm sure you read the relevant sessions of the Matrimonial Causes Act that I guided you to look at. Please, I'd like to have responses so that it's clear to me that are you hearing me? Are you
Good
listening?
afternoon, ma. Yes, ma. We can hear you.
Excellent.
Yes, ma'am.
Excellent. Yeah, so did you manage to look at the contents that I sent to you?
Truthfully, I
Did you
was
manage?
just able to look at like the general overview of the section. I'm yet to do a thorough research into it, ma.
Okay. So when do you plan to do that thorough research? Anyway,
Today.
excellent. You're writing your you've done the thought CA.
They
It was
cancelled it this morning.
postponed, ma.
Okay.
Ma, it was
Okay. I see. Okay. All right. So, I think let me just go straight to the class then. I'm sure you would I'm sure would you'll get around to looking at the other issues, and you get around to looking at the subset at the sections that we talked about. Now, the first thing I want us to know about the strict topic of dissolution is that either both parties, husband or wife, can petition for dissolution. So there is no discrimination. There is nothing like, oh, it's only the man that can do so, or it's only the woman. Both parties can apply for petition. And of course, the petition itself must be accompanied with an affidavit detailing the requirements of the law. And to do that, one must look at the provisions not only of the Matrimonial Causes Act, but also the Matrimonial Causes Rules. And that is guided by Order 5, Rule 10. Now, I want you to know that there is a bit of debate on that Order 5, Rule 10. Now, which also goes to address all that we have been discussing as to the internal and external legitimacy of dissolution of marriage. That is, within the terms of privacy of the couple and the requirements of the law as to whether or not there's some legitimacy in society actually interfering in what seems to be a private matter of marriage between the couple, and when they can decide we don't want this anymore. So the requirement is that, first of all, there must be a petition and there must be an affidavit accompanying that petition, and that affidavit must be verified by the petitioner. Now, the debate you will come across as lawyers will be that some people interpret that Order 5, some cases have interpreted that Order 5 Rule 10 as the affidavit must be on the same continuous sheet as the petition and must be verified at the end of the document by the petitioner, that every content, everything he's saying there is correct and true. Then some people say no. Some cases, these are judicial decisions, or I will give you some of the cases. Some of the other decisions say no, that it doesn't have to be so, that the petition can come differently and the affidavit come differently. And that there is no strict rule that the document must be a continuous sheet and the verification must come at the end of that document. So you look at the case of Unegbe and Unegbe, Unegbe and Unegbe. That is one line of authority. Then you look at the more recent case of Omokiate. Omogiate and Omogiate. Omogiate and Omogiate. 2021. LPALR. Now, what is the difference between the two lines? The two lines of authority. The simple difference is that some people, the first line of authority on Unegbe insist on strict application and compliance with what Order 5 Rule 10 has said. And the reason, of course, you can tell from what we've been discussing is because that line of authority do not support divorce. They don't support dissolution. So if you must do dissolution of marriage, the idea is that you must comply with strictly everything the law has said. Then this other line of Omogiati and Omogiati seems to be saying that what is important is substantial compliance. In other words, have you complied substantially? Is there a real case to be decided? In other words, is there real trouble in this marriage which we should look at? And if possible, to send the parties their way. So that is basically the difference between the two lines of authority. Do you understand me so far? Because I appreciate this is 300 level and I want to be careful with technical use of language, and I want to be sure that I am addressing us, that we are interacting. Do you understand me?
Please, ma, I didn't get the stance of Omogiati and Omogiati.
Their own stance, which you have to go and read the case, is that what is important is, should there be substantive? Is there substantive compliance? The two lines of decision is, one is strict compliance, the other is non-strict compliance. The second line, the first line is comply with what Order 5 Rule 10 has said. The second line is not necessarily. What is important is, has there been reasonable compliance application before the court? Now, if you look at the case of Olaniyan and Olaniyan, you will tend to agree that what is important is substantial compliance. But the existing law, which we must know, the existing law is that you must comply strictly with Order 5 Rule 10. And the petitioner is the person to do so. The petitioner is the person to agree, is to comply, not the respondent, not the cross pleading, but the original person who is bringing the case to the court is the person who must comply with Order 5 Rule 10, which requires that the petitioner must come to court stating the ground on which the marriage needs to be broken, which is that the marriage has broken down irretrievably, and then provide the facts on which he's relying in an affidavit. Now, that point is that affidavit and the petition should come as one document, and at the end of that document, the petitioner should swear an oath to which deposed to that affidavit, and it should be on a continuous sheet. Now, the other argument is that it need not be so. And the reason that seems to be gaining ground today is because there's a recent decision, Olaniyan, that is even saying that a petitioner need not be physically present in court. And what that means if you are saying the petitioner need not be physically present in court, it will mean that the existing authority, which states that the affidavit must be strictly complied with, the petition must be strictly complied with, and verified in court, will no longer be good law. Because if the petitioner is not present in court, then how will he dispose? How would we work with affidavit? So Olaniyan and Olaniyan is saying that the petitioner need not be in court, that he can send people to provide evidence, and that evidence, based on the evidence, oral and written, the court can dissolve the marriage. So with that position, it will seem that our jurisdiction is now tending more towards no fault jurisprudence in dissolution of marriage. Because if you are making liberal rooms, if you are making it more liberal for marriage to be broken up, then that's what it tends to be tilting towards. So the cases you need to look at on this topic and come to your own conclusions are, I'm giving you the cases now that you need to look at to come to your own conclusions. You look at them, read the cases your own self. I'm just going to give you 3. So you read the cases your own self and come to your own conclusions. You, first of all, state the decisions of the court, the ratio decidendi of the court, then come to your own conclusion as to whether what the court has said is correct. After we have discussed the matrimonial, we are discussing section 15.2 this morning, as well as section 16. Then you look at that order 5 rule 10 of the matrimonial causes rule, your own self. Then you come to your own conclusions on which position is more accurate. The other issue which you may also come across is when you look at that order 5 rule 10, whether that verification of petition and affidavit should apply only to the petitioner, or it should also apply to other pleadings that guide the question of dissolution of marriage, such as the response, then cross petitions, replies, and all other, which of course you meet at the law school. But these are just preliminaries for us to be able to discuss section 15.2. So Omogiate and Omogiate is 1. I've given that to you. Did you get that?
Sorry, ma'am, please can you spell the Omogiate?
I cannot come here and be spelling Omogiate to you. Did you not study English? It's just are you not a Nigerian? You spell it as I've pronounced it. Can I be spelling to a 300 level student? Are you in primary 1? Look at Omodo and Omodo as well. Omodo and Omodo. Then look at Unegbe and Unegbe. I think that's okay for you. Unegbe and Unegbe. I think you may also look at Oyedu and Oyedu. That should be okay. You also look at Oyedu and Oyedu.
Sorry, ma, please can we get the citations of the case, or just like where we can find them?
But This is 300 level. I do not expect that you're asking me this question. You first go and Google it to be sure that you're even going to look at these cases. You don't have to. When I call a case for you, the first thing I expect you to do is just put it on your Google and get the citation. Is when you don't find the cases that you can ask your class rep to come to me to say, oh, we cannot find the citation of this case. If you're asking me for the citation, it seems to suggest to me that you've not been studying law. And this is 300 level. I expect that you've been studying law. You cannot be asking me of citation of cases in this day and age. Because even the citation I may give you may not even be where you find it. You can find it in another report. I may give you LPAR, but you may find it in Nigerian Weekly Law Report. I want you to demonstrate seriousness, to demonstrate that you are serious with your studies. Unebwa and Unebwen at any rate, if you want citation, is 2004, 11 NWLR at 884, page 332. That's the citation I have. And I'm sure you'll find this in other citation. Omodo and Omodo is 1966, 1 MLR, page 238. Omogate is 2021 LPELR 56018. Olaniyo and Olaniyo is 2024 LPELR 62816. 2024 LPELR 62816. So now that we've disposed of that preliminary issue, we'll now go straight to section 15.2. Can somebody read section 15.2.1 to me? Section 15.15. Can somebody read
Section
1? Yes.
Section 15, subsection 2. The court
One, I
hearing a
said
petition.
one. Section 15.1.
Oh, sorry, ma'am. A petition under this act by a party to a marriage for a decree of dissolution of the marriage may be presented to the court by either party to the marriage upon the ground that the marriage has broken down irretrievably.
What do you understand by this? What do you understand by this?
It means that the husband or the wife are qualified to bring a petition on the grounds that the marriage has broken down irretrievably.
Exactly. And irretrievably means what?
That it cannot be fixed or remedied.
Not fixed or remedied.
It cannot be fixed or remedied. Does any other person have any other way of
Yes, mother, there's no possibility of reconciliation.
Okay. So do you think that makes sense?
Yes, ma, I think it makes sense.
Do you think it aligns with the law in any other aspect of the law? Is there any other aspect of the law that it aligns with?
Ma, let me attempt. I think
Okay.
it might, in a way, align with frustration on that contract.
Frustration. Okay, explain to me why you think so.
Okay, so I think it might align with frustration in the sense that since it is a contract of marriage and the continuance of the performance of that contract of marriage requires that both parties are at consensus at them, where they get to a point where they cannot keep that consensus or consent to the continuance of performance, then such contract has been, I would say, has been frustrated. Like the performance of that contract has been frustrated, and therefore there would be like the relationship has broken down without need or possibility of any reconciliation or any like nothing can be done. That's why I say that, man.
Yes, I agree with you. That's quite correct. So there's another aspect of the law too that I think you can think if you think a bit further, where that kind of concept also apply. Can you think of that?
Ma, I don't know how correct this is, but how about right to freedom of association?
No. Well, I was looking at, but maybe because you're not yet in 400 level, but just bear that in mind. I'm looking at the grounds for grants of injunction. The grounds for grant of injunction. But what the reason I'm bringing your mind to this aspect is to show you that what is happening here is not unique to marriage. It's not unique to family law. It comes in equity. It comes in equity and in contract as well. So this principle, when you look at something like this, you're looking at the theory. So you're looking at what you call legal theory to know whether there is legitimacy in what is happening in this area. So you see that the fact that this principle is somehow also applicable in other areas of the law demonstrates that what is happening in this particular area is not unique to family law. So it's not something that is arbitrary. It is a part of legal theory. It is a part of law. It's in order. It's something that is well thought through and is well structured. So, has the marriage broken down irretrievably? Has the marriage been frustrated? Is there appears to be no way in which this can be repaired, and this is why the law is stepping in. That is the crux of this matter in section 15.1. Now let's go to section 15.2a. Can somebody read that, please?
Section 15.2a. The courts hearing a petition for a decree of dissolution of a marriage shall hold the marriage to have broken down irretrievably if, but only if, the petitioner satisfies the court of one or more of the following facts. A, that the respondent has willfully and persistently refused to consummate the marriage.
Now, do we think that this is something that is reasonable as a fact to prove that the marriage has broken down irretrievably? And how do you say it? Do we think that this is something that is reasonable to constitute a fact to show that this marriage has broken down irretrievably?
Good afternoon, ma'am.
Yes, good afternoon.
Yes, ma'am. I think it is a reasonable fact or ground for saying that or for opining that the marriage has broken down irretrievably because consummation is if not the essence, one of the essence of marriage. And if one
Why do you say is the essence? Why do you think is one of the is essence?
because of it's like a physical manifestation of union or unity, like when they share each other. So I feel like that's, and also it's also the way to procreate, like to give birth to kids. And
Exactly.
I don't
Exactly. Wait. Exactly. That's what I want to hear you say. Because this is very crucial to some debates in family law, which you must know. Now, is it really the case that marriage is for purposes of procreation? Or should it be for procreation? That is number one question. That is number one question. Then number two is it really necessary that parties to a marriage must have sex? Is it impossible for the parties to a marriage to have compatibility, play around, be happy, cook their food, eat, have companionship, and even adopt a child, even adopt children without the issue of sex and procreation?
I think it is reasoning. Okay.
Bearing in mind the problem that seems to exist in the world today, in which there seems to be a crisis of population, that the earth is overpopulated. So bear that in mind in your response. Okay, yes, I'm listening.
Yeah, so I believe consummation or sexual relations is necessary for companionship. Though in some very rare cases, two of them may be able to stay together, but I don't think it applies in case of marriage. Because when they come together to form the union of husband and wife, so I believe that then they are ready to share each other as regards
What if before they entered that marriage they discussed it, and on spiritual grounds, because there were there have been religious people who, even when they were in marriage, decided they were not going to have sex, that sex was diminishing of spirituality. So yes, what if they had agreed before they went into that marriage that there will be no sex?
I don't think that agreement is I don't think it's reasonable, and I think it's against public policy per
How can
se,
it be
because
against public policy? Which public policy is it against?
like to contract that they don't want to have sex, because that's one of the duties of that's one of marital duties. So it's just like the husband saying that
Where is the duty? Where is the duty stated?
mine is in common law and even in
Which
society.
common law? Give us the citation, because it may even be the case that, okay, the law may also tell them how many times they may have sex, if you claim that there is such a duty. Is there such a duty, or is it a presumed aspect of marriage? Is there a duty, or it's simply presumed?
I think it's a mixture of both, man.
So you
Both
cannot say.
presume.
So you cannot say
Yes.
it. Anyway, let me listen to somebody else. Uche, please. Uche, you can speak.
Okay, ma. So I think, first of all, it is a reasonable provision. First, because already the Act has already stated under Section 5, I think 1A, that inability to consummate a marriage is one of the grounds for which a marriage can become voidable. When either party is unable to or incapable of consummating that marriage.
Yes,
So
thank God. What is the meaning of voidable?
So it means it is valid, but the existence of this
So
state of affairs.
it is not that it's invalid. Okay. Okay,
Yeah,
go on. It is not that it's invalid.
yes, it's not invalid, but like the existence of the state of affairs brings it into the area of voidability
Mhm.
on the part of either party.
Hmm.
So I think because at the like from the onset, this act has already stated that the incapability to consummate a marriage is a ground for which a marriage can become voidable. Then coming further to now state that for a marriage to like one of the things that could make a marriage to get a marriage dissolved would then be if there is willful refusal to consummate that marriage is restating the like, so I would adopt your word, man, is restating the presumed duty of both parties to consummate the marriage for it to be a valid marriage under the eyes of the law. Again, marriage is not a would I say an imperative relationship, or there's no force of law that says that you must marry. But the moment you decide to conduct a statutory marriage under the provisions of the Nigerian law, there are certain requirements which that marriage must go by or must adapt to. And if you do not want to abide by those requirements, then you should not conduct a statutory marriage. So where you have decided to conduct a statutory marriage, you have to like to do it with cognizance to the requirements of the law, of which consummation is one of those. So I think it's a valid or a reasonable
Reasonable.
law.
Okay. All right. Favor. Yes, Favor.
Good morning, ma. I've put my hand down.
Okay, you agree with what they've said. Okay,
I don't want to talk again.
why?
I did not really have so much to say. It was just a bit.
Okay. Okay, Deborah.
Okay. Yes, ma. Good afternoon, ma. So, based on the question you asked rather, so I'll say that consummating a marriage is more like perfecting that marriage. Because if you say that it's a union of a man and a woman, so for that union to be perfected, I think they have to consummate it. That's what I want to say. Thank you.
Okay. All right. Thanks very much. Is that all? Is there any other person that wants to speak? Oh, I'm
Yes, ma.
seeing. Okay. Who is speaking now?
Gabriel, ma.
Okay. All right. Go
I
on.
have a quite contrary view as to why maybe consummation might not be necessary in the sense that, marriage is a like there's privity of contract in marriage in the sense that, it's a private relations, it's between, both partners. So, and I feel like, um, when the law starts to put, um, cases, or how should I say it, on something that's supposed to be private between, like, because it's based on consent. If probably both parties have agreed that, oh, when we are coming into this marriage, we will not have sex for a period of time, especially when it comes to maybe things like when they are fasting or when they are doing other spiritual activities. It doesn't matter how long, because I mean people will be fasting for 1 whole year and they might decide not to have
But
sex. So
the
bringing
law says persistently, willfully, and persistently. So it cannot be because of fasting. It cannot
okay,
be
ma, what
this. Mhm.
if it's a case where probably the person is or has an accident, or probably something like that, or maybe if
Exactly.
one of he has a venereal disease and both parties knew about it before
Mm-hmm.
they got into the
Yes,
marriage.
yes. I generally don't think that session should still be that should still be a real. Oh, somebody else wants to say something. Um, Tove, I can't see your full name. Oh, I'm not very pro with all these things.
Good
Yeah.
afternoon.
Ebenezer, you want to say something?
Yes, ma. Good afternoon.
Good afternoon.
Yeah, what I just wanted to say is that the right and duties of the parties in the marriage are actually such that are imposed by law. So where you've actually decided to be a party to the marriage, then it's actually required of you to fulfill the legal effects of that particular marriage. So if you've actually contracted a statutory marriage, one of the legal effects of a statutory marriage, of course, is consortium, which also includes consummation of the marriage. So it's the law that imposes the duty, and failing to actually comply with that law is actually an infringement, for the purpose of which an injured party can actually bring an action to court, maybe for the dissolution of the marriage, or maybe to declare the marriage a nullity. So I strongly believe, unless there are peculiar situations, which of course the law also recognizes, like the venereal disease that Gabriel talked about and everything, except there are all those exceptions. Without those grounds of exceptions, I think the law is explicit. So where you've actually conducted your affairs or arranged your affairs in accordance to a particular line of law, you cannot otherwise say that you are not you are not obliged to follow the law. Failure to actually follow the law will give ground for that particular marriage or that
what we are asking is whether what we are asking is it's Ebenezer speaking now, right? What we are saying is, is it a realistic position to remain in our laws?
And yes, I from the reasons I did so far, I'm actually saying it's actually reasonable.
It's reasonable.
Meaning that if you've actually conducted your marriage,
so you are saying,
then you should be able to comply with the legal effects of the marriage.
Okay, so the petitioner should be successful.
Yeah.
Okay.
Yes.
So what about the feelings of the respondent? Because obviously the respondent is not in court because the respondent does not want the marriage to end. So
I think
should we not consider the position of the respondent?
I think the words of the law are very explicit. It says persistently, willfully and persistently.
No, we're asking
that's
now.
Actually,
no, the question I'm asking is, we are trying to look at this law, whether it's one that should remain there in law. It's the law. Nobody's arguing with that. That's the position in law at this moment. But we're asking, is this something reasonable and realistic? Should the position of the respondent not be taken into account? That the respondent obviously does not.
I think it's actually reasonable, and the subjective feelings of a particular person should not really be the concern of the law.
Now, what is the meaning of irretrievable breakdown? What if the respondent can adjust to this position, can change? What if circumstances can lead to the change? Meanwhile, the court has broken down the marriage, has dissolved the marriage.
That means that it was not willfully and persistently.
No. I don't know if willful and persistent, yes, for 3 years. But in the fourth year, the respondent now readjusts his or her emotions. Meanwhile, the court has dissolved the marriage in the 3rd year. That's what we are saying.
I think
because this is a question of sex. Is this a question of sex that from scientific evidence and psychological evidence, study of the human mind, the mind affects some things. Say, for instance, at the point in time, individual is dirty, is not clean. And so the other party is not able to respond to him or her, or him to her, okay, for a period of time.
Yes,
but things change. This, let's say, is the woman, she joins the church, and then they have good counseling, and then the woman becomes cleaner, she begins to look after herself, she becomes more graceful, and the man changes and is able to consummate the marriage after 4 or 5 years.
I think for all those grounds that I have listed now, the psychological implication and everything, the law actually gives room for all those things. So basically, where all those things are involved, then the law will not consider the marriage to have broken down irretrievably.
No, you still don't understand me. I'm saying that as at the time the petition is presented, okay, there is persistent and willful refusal to consummate the marriage. The person doesn't know why. The person involved does not know why, but there is a persistent and willful position at that point in time to have sex, to consummate the marriage. Okay, but as if the court had not dissolved the marriage, after that period, things change, circumstances change, and the parties willingly on their own consummate their marriage. Would you still say that this fact is a relevant fact in our laws?
Sorry, ma. Can I say
Yes.
something?
Yes, please. Who wants to say something?
It's Gabriel, ma.
Okay. Gabriel, go
Okay,
on.
so thank you. A scenario just came into my mind where, for example, now one of the parties in the marriage was raped. Let's say, okay, the woman, the respondent, excuse me, the respondent was raped. And, because of that, she has suffered, psychological, issues. And, to the knowledge of her husband, the plaintiff, she's suffering. They've probably gone for checkups together, they've gone for counseling together, and she's suffering. And probably the doctor has said that, after some time, she would get back to herself, although he didn't specify the amount of time it would take. Well, he told them that, after some time, she will get back to herself, she'll be able to become normal again. And they go on with this was before they got married, and they proceed with their marriage, they get married and everything. And for a period of time now, they are not able to consummate the marriage. But probably the plaintiff thought, sorry, what's it, the plaintiff? The
petitioner.
And the other party thought that, maybe after a year or after a couple of months, she'll be able to get herself back together. But it's persisting for 2-3 years, just like you mentioned earlier, like 2-3 years. And, and he wants to bring an action against, like, to dissolve the marriage. And my belief too is that companionship is not, sex doesn't really determine companionship or the strength of how a marriage should to be, because understanding each other also, I'm deciding to be with each other despite the fact that they are not able to consummate the marriage on the grounds that she's suffering from psychological, so that's just what came to my mind now.
Yeah, okay. So does any other person have anything else to say?
Yes, ma'am.
Yeah.
Good afternoon, ma'am.
Okay,
So
who
I
is,
think
please, your names are not
Ayomide.
appearing clearly to me, so I don't know why. Go on.
Ayomide speaking. So I think that the scenario that Gabriel has mentioned, this scenario is actually because she had mentioned like 2 earlier, where somebody has been involved in an accident, or where like the person was raped and the person has like psychological it has psychological effects on the person. I think that does not fall under willful and persistent refusal to consummate the marriage. So that might depending on how it's argued, it might come under incapability, and that will not be
Okay.
under dissolution.
Okay,
Under
all right.
nullity.
I think we will not close this subject. I think, okay, so just bear in mind the arguments you've raised, and then we can move to the next one, because I can see so many hands, which I cannot take now anymore. Otherwise, the class will not move forward. I think that you should think about it carefully, and then I think, in my own view, I think that that should no longer form part of our law. First of all, it's an invasion that should not be before the court. I think it should be covered by a mutual agreement between the parties. If the 2 parties can no longer, if the question of sex and consummation of marriage should not be in the public domain, I think that should be between the parties, and the law should cover it in a different way, such as, the petitioner brings a petition to which the respondent does not object. So that should be something that should be guided privately, and not so that particular number 1, I think, is objectionable, should not be in our laws. So now, can somebody read B?
Okay,
B.
Section 15, subsection 2B says that since the respondent has committed adultery and the petitioner finds it intolerable to live with the respondent.
Now, in that particular one, what the crucial guideline for the court is intolerable. In Nigeria, the crucial guideline is intolerable. Why? Do you know why that is the case?
Yes, ma'am.
Please, can you give me who's speaking now?
Good success, ma'am.
Okay, good success, please. Yes.
Okay, I think it's because the husband or the wife in such a case might choose to ignore or forgive such a defaulter.
Absolutely, thank you. And so we have a few cases in Nigeria, VYB and Kuforiji. We have Jadeshola, Jadesimi, and Okotiebo, where these are Supreme Court decisions where it's been clear, it's been stated in Nigeria that generally on the part of adultery on the part of the man, Nigerian women seem to tolerate. And when there's tolerance of that, the court will not consider it. So it must be that the other party finds it intolerable to live with the other. Now, C, please. 15(2)(c).
Please, I have a question.
Yes, please.
My question is on 2B, that since the marriage, the respondent has committed adultery, and is there like a particular, maybe 1 year of marriage, or it has to be maybe just once that the respondent caught maybe the husband or the wife doing the act of adultery, and then just use the person to court?
Yes, there is no evidence that it's limited by time from the law. There is no evidence that time applies to it in the case of adultery. That adultery seems to be, if the parties just cannot live with, the only qualification there is a question of intolerable.
Okay, ma. I'm saying that, does it depend on the number of times maybe I catch my spouse, or would the courts inquire about that?
No.
Just
No,
once,
the question
that's
of
enough for
okay, that's what the question of adultery is once. That's all. It's once. Because the question of adultery is a very delicate matter, because that once can lead to many things. So the court makes provision for it, so that if there is adultery, you can come to court and the law dissolves the marriage. No need to do self-help, because some people can go to the extent of trying to kill or trying to cause a lot of havoc. So the law makes that provision clear. Once is enough. Doesn't have to be twice. One at any rate, that once can be a big issue, because one can commit adultery once and then there can be pregnancy. You understand?
Yes, ma. Thank you.
Okay. All right. So 15(2)(c), please.
Section 15(2)(c) provides that since the marriage, the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent.
Okay. What do you notice about this one?
Ma,
From this provision, I believe that it's quite broad. It's quite broad. So many the petitioner would find this as an opportunity to bring in. It's not so specific. That's why
Yeah. Yes.
Okay,
Somebody
Ma,
else
I
wants
also
to speak.
I think the wording of this provision is done broadly enough to cover instances of, let's say, domestic abuse, which then causes a petitioner to come to court for dissolution of marriage.
Mm-hmm. Yes. Any other comments?
So I think that with the way it's I think it's quite vague, or let me just say it's broad, and it gives room for some element of subjectivity on the part of the judge. So if there's a petition in the court and the judge does not think that it is like that whatever the respondent is doing does not is not reasonable enough to say that the petitioner will not, it's not reasonable for the petitioners to still be living with them. Like if the judge thinks that it's reasonable for the petitioner to still be staying with the respondent, then the judge might not grant the decree of dissolution.
Yeah.
It's unlike the remaining ones that once it's proven, it's proven.
Well, I think all of them, except for the one of 3 years, all of them have the exercise of discretion. They are all discretion, subjectivity on the part of the law, on part of the court. At any rate, in which area of the law does the judge not have subjectivity? Yeah, but it's a valid point. It's a valid point, but just to draw your attention to the fact that all of them, except for the 3-year rule, have subjectivity attached to it. So, but you have to bear in mind that the law provides a guidance for the courts to follow, which is found in section 16(1)(a) to G, as to what will amount to that intolerable behavior on the part of the respondent. Do you understand me?
Yes,
Do you
ma'am.
understand? The law provides a guidance for the court to follow. So even in the exercise of that subjectivity and discretion, the court is guided on what will amount to this conduct. And the burden to prove this is on the petitioner. The burden to prove these issues is on the petitioner. And of course, it's the omnibus provision for dissolution of marriage. In this place, you will see all sorts of things. Some people will bring witchcraft, some people will bring drunkenness, some people will bring all sorts of things just because they want to throw the other party out. So, but the burden to prove any of those things which is listed here, addiction, criminal behavior and neglect, imprisonment, violence or serious harm, failure to provide maintenance, mental illness, all of those things, if your petition is on those facts, the burden is on the petitioner to prove it, which means the respondent can also disprove any of these facts, and the court will act accordingly. You can look at the case of Nana and Nana. You can look at the case of Nana and Nana, 2006, 3 NWLR, part 966. Did you get that? Did you get that?
Yes, ma'am.
Yes.
Yes,
Okay,
ma'am.
okay. Now, can we go to D? Can we go to D?
Section 15(2)(d), that
Yeah,
the
please.
respondent has deserted the petitioner for a continuous period of at least 1 year immediately preceding the presentation of the petition.
Yeah. So what do you say about that?
I can notice that the word immediate, meaning that it seems that if it's not immediately, the petitioner will not have such an opportunity to petition.
Yes. Yes, any other information? Any other thing you can think of here?
I think maybe the use of the word continuous period.
Okay, what would you describe as desertion?
I think abandoning or leaving.
Leaving the house. That happens sometimes. I don't even understand. There's a particular example that doesn't cease to surprise me. You would think all of these things are in the papers, but they are real sometimes. Because I know this particular couple. They seem to me to be decent couple, go to church. They had 3 children, a boy, a son, and 2 daughters. So it's not as if you cannot believe that the woman just got up one day and left the house. Did you hear me?
Yes, ma, we did.
She just got up one day and left the marriage, left the house. Till today, as we speak, as I speak to you, the woman didn't return to her matrimonial.
Yeah.
Very strange. The man had to take responsibility for raising the children. He did everything to appeal to these ladies. I don't even want to state where she went because it's too heavy in my mouth. Huh?
Where did she go?
Come and ask me again. I told you I don't want to state where she went, and you're telling me where did she go. How do you want me to tell you? Things happen in this world. Now, the decision can be a simple one, just like the one I've stated, where somebody just, and it's not only one I know, up to 2 or 3, a situation where sometimes the woman, sometimes the man just leaves the matrimonial home and disappears. So, then the decision could also be constructive in the sense that it could be a combination of all that. It could be a combination of the person just deciding to be absent in the matrimonial home, in the sense of not necessarily leaving the matrimonial home, but I'm sure you've heard of those as well. A couple, they are both living as tenants, or tenants in common with one another. There's no communication, no eating, no nothing, but they live in the same house. And of course, there is the one that we cannot call desertion, but which I'm sure many people know happen. The couple will just the same thing. They're not talking to one another, but if there's a party, they will dress up together and then. But that will not qualify for desertion because there's some kind of cooperation, in the sense that they have actually the marriage is actually at some form of an end, but at the same time they are keeping up appearances with the public. And this tells you you see, for those of you who were arguing about, the court has the right to do this and do that in terms of sex and all that, what do you say about that situation? Such emptiness should not accompany marriages. Marriages should be real and not vitiated. And so a lot of room should be left for liberty between the couple. The intervention of the law should be very minimal. I subscribe to the fact that what needs to be done is actually in early education to forge the curricula of early education as much as possible to help people align with authenticity and good ethics, good behavior, gracefulness. And when that happens, it permeates the general culture of the people. It permeates the general culture of the society and is expressed in all areas of life, rather than a situation where the law is used like a hammer, a sledgehammer in many things. As for instance, requiring people to come to court to determine whether they've been having sex or not. What's your business with that? So, that is the session.
I want to ask for clarification.
Yes.
Okay, so are you saying that there's desertion in this sense can also extend to couples that are living in the same houses but they are not relating to each other?
Yes.
Okay,
that would be constructive. That would be constructive desertion. You understand? That would be which could also come under persistently and willfully rejection to consummate the marriage. But I think that decision is a better place to put that willful and persistent, although to be if you look at it critically, there are some couples too, in the case of the specific area of willfully and persistently refusing to consummate the marriage. Somebody may be doing that, but may be cooking food and may be cleaning the house and may be chatting, may have companionship. Do you get what I'm saying? So yes, I'm not saying that that law may not be valid, that fact may not be valid. I'm not saying it may not be valid. It may be valid, but I'm saying it is not one that should be in the public domain, and therefore it should not be part of the law.
Good afternoon.
Yes.
Yeah, as regards the points you made, so to concede to your point that yes, the law should not be in the private domain, but I think that's why the law puts the provision of desertion and willful and persistent refusal under the provision of voidable and dissolution of marriage. So others who are outside the marriage, they cannot come to court to be petitioning on that ground. So I think it now comes to a point whereby one of the parties can no longer tolerate or deal with the willful and persistence or maybe the desertion of the other. Then that's why the court made the provisions that, okay, if you cannot tolerate this, because the act also said that the court, they must have made efforts as reconciliation. So if they didn't want to consummate, then they must have agreed to, okay, concede, okay, maybe you don't want it often, or maybe it gets, so they must have considered some form of reconciliation. But when one of them doesn't want to tolerate it or accept it again, then they should be allowed to come to the court to dissolve the marriage based on the ground of desertion and willful persistence. So I don't think it's more like an avenue, like a door open to them to come to court, not like as if they have to. So if they are okay with not consummating or not having sexual relations, fine. But when they are not okay with that, then that means that they can come to court. That's why it's under dissolution of marriage and also voidable. So I actually agree with your point that it should not be in the public domain.
Okay. All right. Thank you very much, Mona. Okay. Let's go to the next one. Okay, let me give you a case that you should look at with that. Ibue and Ibue. Ibue and Ibue. And that is 2023 LPELR 60748CA. 2023 LPELR 60748CA. That's Court of Appeal. Okay, so we go to 5. Is the time up? Oh, we just have 10 minutes. Okay, 5, please.
Section 15 sub 2E, that the parties to the marriage have lived apart for a continuous period of at least 2 years immediately preceding the presentation of the petition, and the respondent does not object to a decree being granted.
Yes, in this particular case, you must establish that the living apart for 2 years was continuous and that the other spouse does not object to the dissolution of marriage, which is very good. Just like Emmanuel was saying, that willful and persistent refusal could also come here. You know, that is more tolerable here than to have that in our statute books. So you can look at the case of Bakari and Bakari. Bakari and Bakari. And that is 2016 LPELR. 2016 LPELR. Can we look at F now?
Section 15.2. No, we've already. Okay. Section 15.2F. That the parties to the marriage have lived apart for a continuous period of at least 3 years immediately preceding the presentation of the petition.
Yeah. So in this case, the parties must be living apart. So what do you see here? What can you identify here from the wordings of this subsection?
Okay, ma, I
difference
can
between
notice
F
that. Okay.
okay, the difference between
Hmm?
F and E is that F doesn't provide for the respondents to not object to it.
Okay. What else?
I can also notice that E is 2 years while F is 3 years.
Okay, what else?
And I noticed that it must be immediately preceding the presentation of the petition. So
Okay.
like they must have lived apart before.
And it must be continuous. Now, but this one of 3 years, you can see that they must be living apart. They must be living apart. Can you see that they must be living apart and there must be no question of living together in the same house, like the example I gave to you? Do you understand? There's no
Yes.
question of, oh, maybe they are living in the same house, but they are not talking to one another. This one is that there must be clear difference in residential addresses. And once it's 3 years, there is no discretion, no subjectivity on the part of the judge, once it can be proved. So if somebody is interested in this particular matter, they must show that they have 2 different addresses and there is no question of breaking it at some point and coming together again. And the most relevant case is the case of Omotunde and Omotunde. You get that? Omotunde and Omotunde. And again, you notice that there's no defense when it comes to this 3 years rule. But in the case of the 2 years rule, the respondent can show that it is the petitioner that caused the problems that led to he or her living away from him. In the case of the 2 years, the respondent can disprove what the petitioner brought about. That, that it was the petitioner that brought about the circumstances that led to the respondent living apart from the petitioner. But in the 3-year rule, there is no defense. Once you can prove that, so it means that if you don't want the marriage to end, you should not allow it to get to 3 years. Before it gets to 3 years, you should present your petition. Do you follow me? Do you follow me?
Yes.
If you and your spouse, if the spouses are living apart, then one must not allow it to get to that 3 years. Before it gets to the 3 years, the other party must be in court.
Ma, what's he in court for? Since he doesn't want it to end.
So, well, I'm trying to understand. I'm trying to present what I'm saying in a more in a clearer way. Because if it is 2 years, if it's 2 years, the respondent can disprove. The respondent can disprove the petitioner, the source of the petition. But if it's 3 years, there is no defense. The court does not have a discretion. I think let me just leave it that way. Let me just make it simple, what I'm saying. Then you can draw your deductions. If it's 2 years, the 2 years rule, the respondent can disprove what the petitioner is saying by saying that it is the petitioner that created the circumstances that led to the parties living apart. Whereas if it's 3 years, there is no discretion. What the court has to do is dissolve the marriage. Do you get me? Do you get that up to that point?
Yes, ma'am.
Yes, ma'am.
Is up to that point clear?
Yes, ma'am.
So the other point I want to make about what should happen, I will leave it for another class. But the main thing I want to relate to you is that the 3-year rule has no defense, whereas the 2-year rule can have a defense. Now, Gabriela, do you want to say something? Gabriel, you're raising your hand. Yes. What do you want to
Hello,
say?
ma, can you hear me?
Yes, I'm hearing you
Okay,
now.
I have a
Yes, go
okay.
on.
In a case where there's a situation where probably before marriage, one of the parties lied to, one of the other party, and that was like that situation or that circumstance was one of the grounds for which the other party agreed to go into the marriage. So maybe, for example, now, if one of the parties lied to the other party saying that, oh, I don't have a child, or I am a virgin, or something like that, when they now get to the marriage and they get married and the other party then finds out that, oh, the partner was lying to him, or her partner was lying to her, or something like that, is it a ground for dissolution? Ma, do you hear me?
Yeah, I heard you. I'm trying to think it through. At any rate, we don't have time again now. We just have 1 minute. So let's leave that question for the next class. So I'll leave that question for the next class. The question is, let me get your question right again. The question is, a party has lied about,
Yes, ma'am.
say, what?
Oh, it could be a couple of things. For example, now one, maybe both one agreed to marry the other on the ground that he doesn't have a child, or the other agreed to marry the other on the ground that she is a virgin, or maybe this one is
The
a
only
particular
place
religion.
that one can get into will be 15.2c, that the conduct of the party is such that has made it intolerable
Behavior.
for
Okay.
So now one will look at the guidance of the court in section 16.1 to A. Would that, for instance, fall under serious misconduct? Can the court expand the interpretation of serious misconduct to accommodate that position? What do you think? So otherwise, let's just think through this for the next class.
Sorry, ma.
And then the other one I want us to look at is the point I was making about what I was making about E and F. That E and F, what should a person do in between the period? Because what should a lawyer do, or somebody or the parties themselves do? That, look, 2 years, this is 2 years. The 2 years is that a petitioner can come to court and say that immediately before this period, dash, 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 and that the other party does not object to the dissolution. Okay, now the third one, the 3-year one, which is F, says that the position of our law today, from the case of Omotide and Omotide, is that the court does not have a discretion. That once the parties are living apart for 3 years, once there's evidence to show that the parties are living apart for 3 years, then the court does not have a discretion. The marriage should be dissolved. So those are the two things I want us to look at, to see what can be done so that the time does not count for 3 years. What can the party who does not want the marriage, which is what somebody raised for me the other time, what can the party who does not want the marriage to end do so that it does not get to that 3-year period? Do you understand my question and where my mind is going?
Yes, ma'am.
What do you
Yes.
think should be done? Because 2 years, if you want the petition to succeed, okay, the respondent can disprove it. If the respondent can show that for 2 years, in the one of 2 years, the petitioner was the one who caused the circumstances that led to the respondent staying apart from the petitioner. Do you understand me? Do you understand me?
Yes, my
Which
like
means that
yes.
that E is a difficult fact to prove.
Okay.
Whereas F is the easier one, because if you can show that the two parties have lived aside, apart, well, let's think about it anyway, because E seems to be providing for the parties that just want to break up. They don't have issues. Anyway, we keep thinking, let's look at it. The next class, we'll discuss that and see how it goes. Okay?
Okay, ma'am.
Okay. Thank you very much.
Thank you, ma'am.
See you next class.
Bye-bye.
Bye.
Bye-bye, ma'am.
Bye.